sir.
Your Honor,
the document.
we can't proceed.
The document.
We can't proceed without jurisdiction.
All right, I have an idea, sir.
Can you hear me now?
Yes, now we can hear you. Very good. All right, state your name for the record.
My name is Fernando Gonzalez, living man.
Very good.
I'm
And we already have
my
appearance of
corporate
Mr.
fiction of the
Duffield
exact same name.
in regard to the matter for motion to dismiss,
Your
Mr.
Honor.
Gonzalez.
Your Honor.
I did hear you identify yourself as Fernando Gonzalez. Thank you. Please proceed with your motion
Yes.
for dismissal.
I'm here representing my corporate fiction of the same name, and I'm here to motion.
Well, you're here as
to.
No, you're here as Fernando Gonzalez, because
Right,
if you're
but
not
I'm
here
not-
as Fernando Gonzalez, I will have to issue a bench warrant for Fernando Gonzalez.
You and I both know I'm representing my corporate fiction, the all caps
You
name.
cannot do that. You cannot represent a party other than yourself, sir.
Well, then we got a problem.
You and I both know that. So
No,
proceeding
that's
as
not true.
Fernando Gonzalez,
If
do
I
you
own
wish
a
to
name-
address your motion for? Do you wish to
If I-
address your motion for dismissal?
Yeah, I would like to challenge
Please do
jurisdiction
so.
like you didn't. I'm here by special appearance to challenge jurisdiction and motion to dismiss for lack of.
Here we go again. Another self-proclaimed living man trying to outsmart the justice system with pseudo-legal jargon. Every time someone says corporate fiction, you already know it's going to be a long day for the judge. But this one, he's confident like he's cracked the code of the universe by trademarking his name.
Well, that's not true. Your motion is dismissed and denied because it is not based on any actual recognized legal basis. So in regard to the trial,
I object to that.
Okay, that's fine. You can
strongly.
object. And upon receipt of your judgment, you can go ahead and file an appeal on that if you so choose, but we are proceeding. Mr. Duffield.
Thank you. I would call Deputy Louise Hempston to the stand. Your Honor, would you like me to approach the podium, or may I stay at the table through the duration of questioning?
You can remain in the chair.
Just have a copy of my.
You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, sir.
Have a seat. State your name. Spell it for the record.
Louise Hempston, Hempston.
Very good. Please proceed.
Thank you. Deputy Hempston, where are you currently employed?
Allen County Sheriff's Office.
How long have you been employed at that location?
Almost 5 years.
All right. And what are your job duties entail?
Road patrol for the Sheriff's Office.
Do you recall making a traffic stop with Mr. Fernando Gonzalez? I believe it was June of 2020.
How patient the judge stays here. This is a masterclass in courtroom composure. The defendant keeps bringing up made-up legal terms, and the judge still gives him room to speak. Most judges would have snapped by now.
And that's he.
What is your objection?
He's labeling me a driver when he has no proof that I was transporting goods, services, or passengers for hire.
Your objection's overruled. Please proceed.
Thank you. Again, did he provide any the documentation that you requested?
When I asked for them, he said that he did not have them, and then he told me he wasn't driving, he was traveling.
Do you recall what type of vehicle the individual was in?
It was a silver Ford, I believe it was a Focus.
And to your knowledge, is that a motor vehicle?
Yes, sir.
Were you able to identify the driver in some capacity or in some way?
Yes, I was. There were some legal documents. The driver would not identify himself, and I attempted to look at the VIN plate on the front dashboard underneath the front windshield, which is obscured by some paperwork. That paperwork for legal documents and identified a person's name and also identified an address. I used that address and that name using Lean to come up with a name and a picture that identified the same person as was driving the vehicle.
And did you, when that was pulled up in your law enforcement information network, did that include information on whether the individual had a valid driver's license?
Send operator status was denied, suspended. So
But I'm not driving, I'm traveling line. Classic sovereign citizen script is their favorite line, as if saying that somehow erases traffic laws. The deputy's face says it all. Here we go again.
Well, then you can either take your hat off or be held in contempt of court, or you can turn your camera off. One or the other.
I'll turn my camera off. I don't like being told what to do.
Okay, very good.
May the record reflect that.
He did identify, yes.
And so you said that this traffic stop occurred northbound US 131 near the 66-mile marker?
Yes, sir.
To your knowledge, is that within the borders of Allegan County
Yes, sir.
in the state of Michigan?
Yes, sir.
And US 131, is that a limited access highway?
Yes, it is.
All right, at this point, Your Honor, I would ask to move to admit the People's Marked Exhibit 1 under MCL 257.204A, given that it is a record kept by the Secretary of State in compliance with that statute, and is a certified copy of such, if I may approach.
You may.
For the record, I would state that I emailed a copy of this document to the defendant at the email address I had on file approximately 25 minutes prior to the start of the trial time.
All right. Any objection to the exhibit, Mr. Gonzalez? No objection, it's admitted. Anything further?
Your Honor, I have no further questions for this witness at this point. Thank you.
Mr. Gonzalez, do you have any questions?
Now, this is where it gets hilarious. The man refuses to remove his hat unless he's paid $500. You can actually see the judge's patience evaporate. Instead of escalating, the judge just says, "Fine, turn off your camera." That's such a subtle power move. Authority with zero emotion.
The document.
We can't proceed.
The document.
We can't proceed without jurisdiction.
All right, I have an idea, sir. You don't interrupt me, and I'll try not to interrupt you. So go ahead and make. If you've indicated that you didn't have any questions, and that's fine. I told you the reason that in regard to that, the notice of lien you sent, it's a meaningless document from a legal point of view. All right. Anything else you'd like to establish on the record?
Yeah. What about my
FOIA request? He has nothing further. You wish to sum up any arguments you have?
I object.
Mr. Duffield.
You're not letting me proceed. You're not letting me defend myself.
Sir, you're not proceeding. You keep saying you want a motion for dismissal, but I've already directed that is denied.
But I asked you, did you read the FOIA request that I just sent you a while back?
Sir, no, I did not read a FOIA request because I haven't received one. So I can tell you, and not only that, that would be irrelevant to this proceeding.
How would you know without reading it first?
Anything further?
How would you know without reading it first?
Because a FOIA request in regard to this matter, we are talking about a trial for driving with a license suspended. Do you have anything pertinent to that in regard to this trial?
Yeah, the FOIA request that I sent you. Pretty much
anything other than that, sir. I am deeming that to be irrelevant. You can take that up on appeal as well. You can take that up on appeal as well. Well, sir, we're on trial. You don't file things a moment before a trial and then expect the court to receive it. First of all, we didn't receive it. But in any event, sir, I've already made my ruling. Do you have, sir? I'm not going to argue with you. The matter that is disposed of, you can address it on appeal.
That's why we're here today, is to argue.
Sir,
now, listen,
sir, you can address it on appeal. You can address it on appeal, sir.
You want to get out of this so bad, you don't even want to fight with me on this, or what?
I don't want to fight with you at all, because that's nonsense. I don't want to fight with you. I have nothing against you, sir. I'm just asking you to proceed with pertinent information.
Well, how would you know if something's pertinent if you don't look at it?
Here's where things spiral. Gonzalez keeps circling back to the same point. Jurisdiction. It's like he believes if he says the word enough times, the case disappears. You can sense the judge's exhaustion now. That quiet frustration of someone trying to reason with a brick wall.
Your Honor, my office's obligation is to prove the elements of this crime, each one beyond a reasonable doubt. The elements being that first, that the defendant operated a motor vehicle, which is defined under MCL 25733 as a vehicle that is self-propelled. I believe, based on the testimony, that the vehicle at issue in this case meets such a definition. Second, that the defendant was the one who operated that vehicle on a highway, US 131 being a limited access freeway near the 66 mile marker. I believe we have.
I object.
Is the only testimony in evidence compels that conclusion. And third, that at the time that the defendants, at the time of the travel, or of the driving, the defendant's operator's license was suspended or revoked. We've heard testimony from the deputy that she cross-checked using the law enforcement information network, which showed that the defendant had a suspended or revoked license. Further, we have since procured a copy of the Secretary of State certified driving record that the Secretary of State maintains by statute, which also shows that it has been suspended. So I believe we have met all of the elements of the crime beyond a reasonable doubt, and I would ask that the court find such. Thank you.
Prosecutor steps in and completely resets the courtroom's tone. Precise, methodical, calm. He lists every element of the crime like a checklist, undoing 15 minutes of nonsense in under a minute. That's professionalism.
I thought this case was squashed a long time ago, or else I would have prepared for trial, which I never even consented to last time I challenged jurisdiction. I should get more time to defend myself if this case is going to be going forward without me being able to defend myself. That's not fair. I thought this case was squashed the moment I sent that ticket back with all rights reserved.
Well, that's
With 72
nonsense,
hours,
so that is,
with nothing
you've
to base
known this
that
case
on
has
other
been
than-
pending. This case has actually been pending since 2022.
That's not my fault.
Here,
I
well,
rescinded
that is
ticket
indeed
in
your,
72 hours.
in any
So
event.
your guys'
I do find that the
fault for-
people have proven their case
Honor-
beyond a reasonable doubt. I do find that he's guilty in this matter. Fines are $250, state costs $50, court costs $200, crime victim right fee of $75.
You don't have my consent on any of this.
And $150 in bench warrant fees.
And I want my bail back too.
That would be then a total of $725, and I'll give you 90 days to take care of that.
That's
Is there
not gonna
bond?
happen.
Is there actually bond that's been posted? We have $300 bond. We'll apply a bond,
I object to that.
and we're applying it.
For a victimless crime, that's,
And remaining balance of $425 is due within 90 days. We're all set. We're going to mail out the judgment to you, sir. If you wish to appeal, you're welcome to do so.
thanks.
Exhibit, Judge.
I'm sorry?
Exhibit.
The exhibit's returned to the process.
This ending is pure irony. The judge finds him guilty calmly by the book. Gonzalez objects again, saying, "I don't consent," as if court rulings require permission. It's almost comedic at this point. A real-life courtroom turned theater. What's wild is how polite the judge stays through it all. In a world of viral court clips, this one shows the patience it takes to deal with someone who lives in their own legal fantasy.